And welcome to ESCA Legal Lounge. My name is Kimber Marie Faircloth. I'm an associate at ESCA and will be moderating today's episode. I'm here with Angela, our patents partner, and Nicole, our contracts partner. How are both of you doing?
Doing good,
Good.
thanks.
How are you?
Hanging in there. It's a Monday, that's for sure. So I know for today we talked about discussing advice to early stage entrepreneurs, advice that you would give on protecting their IP and as well as getting their contracts together. So I have a few questions for both of you. To start, I have a question for Nicole. What are the essential contracts that every startup should have in place when launching their business?
Sure. So I'll identify three. I'm not going to include the standard corporate formation, corporate governance contracts. Angela will speak to intellectual property. One of the non-negotiables is insurance, but I'll identify three for purposes of this episode. The three agreements that I encourage my clients who are founders or entrepreneurs or have a startup business that are just kind of in the beginning phases, I recommend three ironclad agreements. One, an excellent non disclosure agreement. A non disclosure agreement, for those who do not know, protects information that is considered confidential or privileged from being disclosed to third parties or other, members of the company that is not intended to be disclosed or released. So I want to ensure that my clients have non-disclosure agreements that protect them, that ensures that confidential or privileged information doesn't get in the hands unnecessarily of employees or contractors who shouldn't have access to it. And I want to ensure that they are protective over their highly valued intellectual property or their financial information. So that's one thing that I encourage my clients to have in place from the get-go. The other thing that I encourage my clients to have in place is, depending on the size of the company, again, all of this is viewed within the lens of these contracts differ depending upon what type of company it is or what industry they're playing in. But I want to ensure that my clients have really solid employment agreements in place. If they're hiring employees who are deemed employees, whether they're hiring independent contractor agreements, because that really outlines roles and responsibilities, scope of work. It has tax ramifications for companies if they're a full-time employee versus an independent contractor. So that's always really important to have kind of those clear delineated roles and responsibilities. And then the third thing that I counsel my clients to have, many of my clients are in a customer or client facing organization. So I want to ensure that they have really solid agreements with their clients and their customers, so that everybody is on the same page with respect to payment, with respect to deliverables, with respect to indemnification and liability, so that both parties, my client and whoever their customer is, or their client, or their supplier, or their vendor, everyone goes into the contract well aware of what's within the four corners of the agreement and what their respective roles and responsibilities are.
Great, thank you so much for that. And I think having those documents ready, that's a good segue into Angela's question. When should a startup start thinking about protecting their IP specifically, and what steps should they take initially?
Yeah, basically, you should start thinking about your IP from the get-go. It is basically one of the first things you should think about when you decide to start a business or contemplate starting it. And that doesn't mean you have to actually set up all of your IP, but you have to think about what would you want in terms of the name of a business and potential trademarks, whether it be the logos, the names, words that you or phrases that you will want to use with your business. You need to think about that up front and think about what that is so that you can put that on your to-do list to consider. And then also you have to think, what are you offering in terms, is it a product, service? If you're designing your own product, you definitely, if you have a product that you are designing yourself, you should definitely think about patents and then figure out if they're what you would potentially want to patent, and that would involve potentially talking to a patent attorney even to get started, or you can do a little bit of research on your own just so that you have that also on your to-do list. And then another thing to think about as well, especially if you're going to be posting images, is copyright law. Whereas you don't have to actually register copyrights, it's good to always make sure that you have records of when you take pictures. If someone's taking pictures for you, make sure you actually have the rights to those things, and really make sure that you think about that when you're starting your business, especially if you're going to have a website and e-commerce where you may be posting these, which I feel like we can all, from our experiences working here, is that we've definitely seen where people just really just grab things off the internet now a lot. And that's something that you should be thinking about upfront. So I think that those are kind of three things that you really should be thinking about in terms of the IP world, and put them on a checklist of things to review. And as you grow and move forward with your business, make sure you're consulting with professionals to help.
I love reframing that as a checklist for those different areas of IP, and then tacking on there the documents, Nicole, that you mentioned, which I have a follow-up question for. So what are the key clauses founders should prioritize in client or vendor agreements to protect their interests?
Sure. Again, it depends largely on the industry and the area in which the company operates. I thought it would be helpful to answer this question with an example so that viewers and the three of us can talk about something, concretely. I represent a number of interior designers. Some are small shops, some are bigger. And all of them have either full-time employees or independent contractors in place. So the most important thing, as I said, in our previous question, was having a contract in place from the get-go that governs the relationship between, in this case, an interior designer and her customer. In an agreement like that, I would want to make sure that I have payment terms really clear and delineated. If there's a payment schedule, if interest accrues, my client deserves to be paid for their hard work. So ensuring that, payment is front and center with respect to both parties being aligned on what's owed. I want to make sure that there's a really clear statement of work or deliverables. Again, both parties should go into an agreement very clear on what deliverables are owed so that neither one feels like something was owed to them that wasn't delivered. And so it's really important to have, to the extent possible, a schedule that outlines these are the things that I want, my designer or my contract partner to work on for me and deliver to me at the end of this. Indemnity and liability is also a really important point. Making sure that I can, to the extent possible, disclaim as much liability for my client as possible. You think about an interior designer, they're walking into an active job site every day where you trip on a wire, you can start, some type of big issue, a flood or whatever it may be. So I want to make sure that I disclaim liability and pre-allocate risk and liability to the extent that I'm able to, whether that's an indemnification clause, a limitation of liability, just making sure that those things are taken into consideration early is super important. And the last thing, which I think is really timely, is having a force majeure clause in place. We think about the wildfires that are going on in California. Families are impacted, homes are impacted, businesses are also impacted. And so you want to make sure all of these natural disasters are taken into consideration when there are deliverables and a scope of work associated, to ensure that there's no unnecessary breach of the agreement and that both parties are operating under an understanding of what happens if a force majeure event takes place.
Thank you so much for those, Nicole. And going back to those terms that we're discussing, the finances and the payments. I know, Angela, you had some tips or some thoughts on what are some cost-effective ways for startups to secure their IP while operating on a tight budget.
Yes, and I think that first goes back to what I was talking about in the prior question, that if you make yourself a checklist and you keep track of your potential patent, trademark, and copyright, what you would want to consider, or what questions you may have for a professional, and basically any other questions you may have. I think that keeping checklists for yourselves and keeping those questions very organized is one way that you can help, because that is basically when you go to talk to someone, you're going to have the information in front of you and have all your thoughts, and hopefully present them in a very more collected way, and not just sporadic, which would save a cost if you are doing things hourly. Additionally, I think that also, just in terms of keeping records of everything and keeping things organized in general when you're starting a business is obviously good, but that also is really helpful for IP, because it at times, especially for patents, it's the date that you actually start disclosing it to someone that you would actually trigger the a disclosure, and then a timeline for when you can actually do your filings. But also with trademarks and copyrights, dates are very important as well in order to file applications. So to have all that information and have it really organized is really a great way to get yourself off to a good start. In addition to that, like Nicole said, that you need to have the NDA. That's really important, because that gives you there will be confidentiality clauses, and is when you are working with others with your ideas, being in a relationship which involves confidentiality will also help preserve your patent rights and help you protect yourself, which will lead to less costs, hopefully, in the long run, and also give you the ability to get the IP you want. And then the third thing that I think would help you be cost effective and also just help you off to a great start is to have to basically have an IP playbook where you can work with a professional to come up and strategize what you want for your brand and brainstorm about what you might think in terms of what kind of IP you would want, and going even beyond the IP to, okay, do I need a website? How do I need to my domain, and what other contracts, going back to what Nicole did, what we would need in place. And really having that playbook would let you look at what your goals are and what you want for your business, and also help give you timelines of when you have to do something by, as opposed to things that you can do later on. And then you can spread it out and help you with your budgeting, and also keep your costs so that you can predict what they are, hopefully, and keep them under control and within your budget.
That's such a great point. That's something that our firm offers is for founders or companies that are in the early phases of development. We'll sit with you and we'll go through an IP playbook. We'll put together a list of agreements that you should have in place, along with the schedule and timing and approximation of budget. Working with founders really closely from the beginning has been a critical part of our business. And so we value that time that we can sit with founders and really work with them to map out, when they want to have certain IP in place, what's important to them, what does the future hold for them in terms of product development, what's something that we should think about, what agreements will they have in place, how many employees do they plan to have. So these are all things that our firm offers to founders and newly formed companies as they begin to think, they can sit down and think, oh my gosh, this is super overwhelming. This is why they have a brain trust of trusted advisors like us to sit with them and make it more manageable. Not everything has to be done immediately. Nobody really has the budget to do that immediately, especially if you're a new founder. So that's something that we love to do with our clients, is sit with them and map out that strategy for them.
Yeah, I do think that that's it's a fun part, but it's also so beneficial for the
Totally.
founders and when they start their business.
Totally. Totally. Absolutely. And they're always so grateful for it, because a lot of founders have, an exit plan that they are thinking of long term, or they're going through fundraising, or they're speaking with investors. And oftentimes, like we've done this a lot, Angela and Kimber Marie, where our clients will say to us, thank you so much for making sure that I was on top of my IP and had these agreements in place, because they are all assets as my company moves through to this new phase. And so it's super beneficial, super valuable.
Definitely.
For your time. I know both of you have to get going. It's a busy Monday, but thank you for being here. And to the viewers, you can catch us on our next Legal Lounge. We'll be posting about those details soon, so stay tuned for the next episode. Thank you both.
Thanks,
Bye.
Kimberly. Bye, everyone.